Are you guys ready? Ben, are you ready?
Yeah, we're totally ready. Let's do it.
Hey, Max, whenever you're ready.
He's in that position. I didn't think he was quite ready there.
That's fine.
Getting full into those exhibits.
Jim, earlier in your testimony, you said, when did you first receive a notice of this written complaint from the inmate?
I'm sorry, I can't hear you.
Yes.
Max.
When did you first receive notice of that written complaint from the inmate alleging sexual assault?
It was probably on, well, if I can look at a calendar, I'll give you the exact date.
So you testified earlier it was October 27th.
It was, well, the sergeant who was working that gave it to me was Mel. And he was working on the 23rd, so his next shift would have been the following Wednesday. So whatever that makes that day. So 23rd, so 26th.
And you were also emailed that report on the 23rd, though, correct?
No, I was not. That letter? No.
Yes.
The first time I saw that letter was when Sergeant Oshbacher handed it to me.
I'm gonna pull up here what I had identified as various emails to and from Kim Lavasseur.
Okay, okay, found it. And this is gonna be 21. Just want to make sure of that. Yes, that'll be exhibit 21.
All right, so turning to the 5th and 6th.
You
Hey.
put it up on your screen if you can.
Max, is this yours? Is this ours? Whose exhibit is this?
I think
It's one that I had shared.
Yeah, it's his exhibit. The file name is various emails to and from Kim Lavasseur. I'm marking it as exhibit 21.
Where is that? I've got open records. I've got that recording, statements, Ashland County jail policy, county rule book, February receipt, full investigation, and Kim Lavasseur grievance filing. That's what I've got for exhibits. What are you talking about here?
Well, the file name is various emails to and from Kim Lavasseur.
I don't have that.
Okay. Let's go to Dropbox. What did you call the Dropbox?
Was that sent to us on some other day than Monday?
I'm assuming it was in the Dropbox because that's where most of these came from.
This might actually, now you said it.
Oh, okay. Well, then it's out.
What did you name the Dropbox? 1 second.
I do see here, I did not upload this in the Dropbox. It was sent after the fact.
Okay,
I would make a request that the hearing officer allow the admission of this exhibit, and in the,
Well, how did I end up with it?
I emailed it to both of you.
When?
Right after, Attorney Hitchcock Cross emailed his amended witness list naming me as a witness on Wednesday at 2:27.
okay.
Here it is, 2/28 is where I got it.
Well, so that's the day before the hearing.
So what is this even for?
And I'll just ask questions. If you don't want it admitted,
That's
can
an
just-
easy way to handle it, right?
I can just ask questions about it.
All right, let's do it.
Okay, so I'm gonna strike exhibit 21.
Well, we're not,
I'm sorry, what was that?
So exhibit 21 was the various emails.
right, which we don't have.
Well, it
Yes.
was, you
Saying that he
do,
sent
but
after the fact.
Yes,
and
hold
Yeah,
on,
we're not
stop,
admitting it.
quiet. So the caption on it was various emails to and from Kim Lavasseur that attorney Lindsey sent on Wednesday, April 12th. I got it at 2:28 PM. It was after Monday, so I'm gonna strike it, so it is not included as an exhibit, and apparently he's gonna ask questions without admitting it as an exhibit.
Right, that's what I understood. I just was surprised that it was an exhibit, but okay, great. We're on the same page. Thank you.
Okay, go ahead.
So Ms. Lavasseur, you stated you did not see that report and you did not receive an email regarding that sexual assault report.
Not that I'm aware of. I did not work. That was, October 23rd was a Sunday. And I do not work Sundays.
So you said not that you're aware of. Is there a possibility you don't recall receiving that email?
Well, I don't work Sundays, so I would have never opened it on a Sunday. But it's possible.
Okay,
I don't
and would
know.
seeing that email recall your recollection of that
Well,
Sunday?
since you only sent it Wednesday, I'm not gonna,
What was that?
I don't recall seeing it, no.
Okay,
The
and
only time I recall seeing that was the day that I originally saw that was on the day that Mel Oshbacher handed it to me.
would seeing that actual email refresh your recollection of when you received it?
Well, I'm telling you right now, the first time I laid eyes on that letter was when Mel Oshbacher handed it to me.
Oh, what was the date of that when Mel handed it to you?
It was, hold on, let me look at the calendar here. October 26th.
Which is a Wednesday, right?
I'm sorry?
That's a Wednesday?
Yes.
Do you have access to your work email at home?
Depends on where I'm at. If I was out of town or hunting, then no, I don't.
So again, you had stated you don't recall receiving this email. Is that what you said on October 23rd?
Correct.
Okay. And I'm going to pull up a document here to refresh your recollection on that.
Is it a document that we have on our side that we have already received?
Yes.
Where is that?
Is this an exhibit?
This is not an exhibit. She stated she didn't recall receiving an email.
Okay,
I'm pulling this document up.
okay.
This is what we had identified as various emails to and from Kim Lavasseur. And it is 2 pages here. The fifth and sixth page of that document that's been identified. And here, Kim, there are two emails from one from Jail Pod to Kim Lavasseur. Your email is kim.lavasseur@ashlandcountysheriff.us, correct?
It was, yeah.
Was. And this email dated Sunday, October 23rd, 2022. Email states, "Hi, Kim, this is a report Jordan gave to Mel. The report Mel wrote. Everything will be on your desk also." And your response on Sunday, October 23rd at 5:01. Jordan, can you please tell Carmen, can you please tell Mel to pull Jordan out of the library somewhere? Tell him that he is who is going to talk to him. The first page of the rules book talks about reporting PREA. Brandon has been out of the cell for many days. In reviewing these emails to and from you on some Sunday, October 23rd, does that refresh your recollection that you did receive that report on that day?
I do not recall seeing that report on that day. I recall Mel Ashbacher handing me that report on October 26th. It was a Wednesday.
So you didn't do anything between receiving these emails on the 23rd and then getting that report handed to you on October 26th?
Well, objection, the document speaks for itself.
The question was whether she did anything regarding this allegation between October 23rd and October 26th.
Right, and my objection was the document speaks for itself.
Well, I think the question that was outside of the document is whether she did anything other than send an email, I guess. Between the
I can't
23rd
hear
and
you.
26th of
Sorry.
October, and honestly, I think you're getting buried in the weeds here.
Yeah.
Move on.
So you stated in your testimony also that Sheriff Zupke, or at that time, Chief Deputy Zupke was unavailable when you initially got this sexual assault report. Is that correct?
Yeah.
What did you do to attempt to communicate with him?
Every time I worked, I would walk over to his office. If he wasn't there, I would go back to my own.
You never sent him an email asking to meet with him?
No. I knew
And-
that the sheriff was coming back and I would speak with him.
And the sheriff was coming back in over a week from that time?
Well, a couple of days, yes. The inmates were already separated. I did not feel that anyone's lives were in jeopardy. And yes, as soon as the sheriff came back, I informed him of the sexual assault immediately. However, as soon as I found out about it, I did act immediately.
When you were initially promoted to jail administrator, you got a pay raise, correct?
Yes,
And you've never seen Kyle Kadot's pay stub since he's been hired as or promoted to interim jail administrator?
I can show you an email.
You've never seen his pay stub since he's been hired?
No,
And you have no direct knowledge that he actually gets paid overtime, correct?
no.
In your grievance filing, which I will pull up next. This hasn't been identified, has it?
What?
The grievance filing?
No, it actually hasn't. So I mentioned that to you guys before.
Yeah.
So this grievance technically has not been admitted as an exhibit. I'm assuming you want to do that?
Yes, I am now.
Okay, so this will actually be exhibit 21.
2-1?
Yes,
All right.
Kim, is this a grievance that you filed after your, with the county after your termination?
Yes,
And the statement here, I have no knowledge of why I was terminated on January 19th, 2023.
yes,
And that was the sole basis that you wrote on your grievance, correct?
yes,
But in fact, you were told of the reason for your termination in your meetings with Brian Zupke, correct?
I had no idea that he was telling me anything. I was getting yelled at after I just got demoted. Literally 2 to 3 minutes later,
And you
I
met,
was in shock. I did not know what was going on.
but he explained to you the reasons for the decision, the employment decision. Correct?
If that's what you want to call it.
Okay, and he also previously met with you and discussed the same topic
No, he did not.
on approximately January 10th, correct?
No, he did not.
Are you saying that you never discussed these issues with him before then?
Never.
Okay, I'm gonna pull up. I do need to play it now. The recording of the meeting on January 19th.
okay, so that is exhibit 5.
So I just want to point out that this is irrelevant. And the reason that it's irrelevant, I think we made this objection before, is the purpose, stated purpose of this meeting was to discuss Ms. Lavasseur's continued employment. So to the whatever extent that there may be any conversations about Mr. Zupke's opinion on her conduct, the stated purpose again of this meeting was nothing other than to discuss her continued employment. So on that basis, this argument here is irrelevant because it's not a reason for why she was demoted or an explanation of why she was demoted. The whole purpose of this conversation, as stated in Mr. Lindsey's letter, was to discuss her continued employment.
Okay, now respond to that.
Got an echo going on here, here.
Hold on.
Okay.
Respond first before you play it.
Yes, the stated reason for that meeting was to discuss.
I can't hear you.
Stated reason for that meeting was discuss her change in employment status.
Well, I think it's admitted exhibit already.
It
So,
is.
I mean, whatever it is, it is. I mean, you can argue what the purpose was, but frankly, it doesn't much matter. It's already been admitted as an exhibit for whatever it's worth.
Right, we're not arguing that the purpose of the exhibit should be admitted. We're arguing that that statement that Mr. Lindsey wrote makes the discussion here irrelevant for the purposes of the telling her about the termination, which is why he's trying to put this in evidence, is for no other purpose than the grievance file.
And
So,
I'll
again-
submit in opposition, I'll submit an offer of proof here that recording clearly states and Lieutenant Lavasseur acknowledges that they had prior discussions approximately a week before this meeting about these same issues.
It's already been admitted as an exhibit. So the relevance issue is moot.
Now I understand. I got it, Mr. Carlson. I'll withdraw it then. Thank you.
I don't know how we're gonna play this. 'Cause it'll echo.
I think you're gonna have to turn down this.
We don't need to play that. However, I will submit an offer of proof here that the video does, and the recording of that meeting does clearly state and indicate that Sheriff Zupke and Lieutenant Lavasseur had previous conversations about this issue.
All right, move on.
Okay. Kim, you don't have any email or other documentation to show that you were explicitly requested not to go to the PPLE meetings, correct?
Just the email from Brian saying I was not allowed to go to board meetings.
And not, it didn't reference the PPLE meeting, correct?
It said board meetings. I took that to mean all board meetings, including PPL.
And, okay. And in the meetings between you and I, you had initially, well, strike that. Just to clarify one item here, where your attorney had accused some form of perjury on the February 16th letter. On the second page, first sentence here, that it says, January 19th, Corporation Counsel provided Lavasseur with a notice that she was being terminated as jail administrator and explained to her that the county intended to rehire her in a previous position as correction officer. You notice the written notice that was provided to you stated that you were being removed as jail administrator and they intended to rehire you, correct?
Can you put that up on the screen?
We can find it. This is the response letter, right?
Yeah, this is exhibit 6.
I'm working on it. I'm just fumbling here with sorry. I've got it up here. Sorry, Max, can you? Perfect, thank you.
Okay, now what did you say?
Yes, it was just to clarify, sentence in a issue that your attorney had pointed out. This highlighted sentence that states that you were provided with a notice that's saying you were being terminated and explaining that.
That's incorrect. It said I was being demoted.
Okay, so you're being removed of your position as jail administrator. But nowhere in this statement does it say that I verbally explained to you any of these items, correct?
No, but you did. I asked you, what did I do wrong? And you said you had no idea. You said, I don't know.
No, stop, the written notice said to talk to Sheriff Zupke, correct?
Oh, so. Yes, it does.
Okay,
I mean, you did say that though.
Oh.
But it doesn't, where it says.
no question is on the table right now, please.
Just, look,
Well,
you're trying to
you
bully this woman and she's not taking it here.
Well-
And you gotta let her finish her answer. So that's what's gonna happen, sir. I'm sorry, but you're gonna have to wait patiently and let this woman speak.
And you put
Hold on,
county intended
hold on,
to
stop. Just
hire
real quick.
her.
Just real quick, it just has to be
Doesn't say that.
responsive to the, hold on, Kim,
I'm sorry. I can't
She
hear
wasn't
you.
finished with her answer and he started interrupting her.
hold
So
on, stop. You will be entitled to respond completely. Just make sure it's regarding the question is all, okay?
great. I think
Yes.
we're ready for another question.
Can I finish about the question you asked me?
I believe you had answered it. There was no further question.
Were
But
you-
it was, you said is about that sentence. It says intended to rehire her in her previous position. It doesn't say anything like that in that letter. It says you may continue your employment with Ashland County. Doesn't
Okay.
say anything about me being fired and rehired.
Okay, so that was the difference. In your opinion, the word continued employment versus rehire.
Correct.
Okay, thank you. So you agree that you have now been provided with reasons for your termination, correct?
Even though they are incorrect and I never received any rule violations. They did give me reasons.
Thank you. So that satisfied your request and your grievance, correct?
They gave me answers, however, I never received any rule violations.
And-
So how can that be?
I'm just gonna object here also to the extent that you're asking for a legal conclusion here from this witness as to whether or not your responsive ex post facto satisfies her grievance request. I'll note in there, she is also requests all available remedies, for example. So with that in mind, I have no other objection.
Tim, do you agree that strike that. I think that's well proven. I have no further questions.
I've got a few. Ms. Lavasseur, when you were testifying to your attorney's questions, you made the comment about the new administrator having a protective status.
Yes.
What does that mean?
It means that he can retire earlier. It means that he's the county pays all of his retirement amount. They pay more towards it. I don't know if they pay all of it. Whereas if you are not protected, you have to pay half and then the county pays half.
And that's because he's a part of the union?
No, he's also part of the union, but because he's a deputy.
And all the deputies are a part of the union?
Correct.
This is kind of a more broader question. Can you kind of explain what your relationship has been like with Mr. Zupke since you were jail administrator through the time that you were walked out of the jail?
Well, I'll tell you, before that, I actually posted on Facebook. I was for him for sheriff. I was all for him. And then he seemed to think I was having secret meetings with Sheriff Brennan, which I was not. It seemed as if he were paranoid, and now I have no relationship with him.
I understand that. And what I'm trying to figure out is, seems like at some point things came off the rails with your relationship. It looks like you're doing okay. And then all of a sudden you're not doing well, not a good working relationship. Do you follow what I'm saying?
I do.
And you're saying that the precipitating factor was at some point he believed you were having secret meetings with Sheriff Brennan?
He did. And as a matter of fact, he said that in that audio.
Okay. The audio that Attorney Lindsey was
You guys
trying.
can't play, yeah.
The recording.
Or, I'm sorry, yes, the recording that you are unable to play.
So when approximately was he thinking that you had secret meetings with him?
For the last probably, maybe, well, if we look and see what the date on my email to Sheriff Brennan is, regarding the night shift sergeants. Because I was trying to be as transparent as possible. That one, yeah, November 22nd. From then on, I would say.
And as that document should be admitted, right? This is our first exhibit in our list here. And again, it's 22/1/22 email from Lavasseur to Mick Brennan.
Yes, and that's exhibit 19.
Can I ask you, just for your reference, how you're able to find those exhibits so quickly?
Sure. So what I've created is a separate folder on my desktop.
Okay.
And what I have done is I left your guys's file labelings on the various files. And then at the end, I just added exhibit 19, exhibit 20. And then what I did is I slid those into a Dropbox, and I'm sharing that with both
Got
the
it.
two of you. So you
And
both.
so do you have them as like thumbnails, or because you just seem so much faster than this than I am? I'm really trying to see.
Right. So the two of you will have a full and complete copy of all the exhibits with the correct numbers on them.
Okay. It's just again, you seem faster, and I'm trying to copy you.
Yeah.
All right. Excuse me for that. I appreciate it.
So that's somewhere in November 22nd, somewhere in late November. So the sexual assault occurred somewhere in October. Well,
Yes.
September, it reported in October.
Right.
I'm just trying to understand why you went to Mick Brennan, and I mean, there's no emails that I've seen or anything of communicating with.
Because I couldn't reach Brian. I mean, I shouldn't say reach as in call or whatever. I mean, he was never around. I mean, seriously, all summer long, he was out campaigning. And then towards the end of the year, he was never around then either. I mean, you just never could find him.
Do you acknowledge that there were some rule violations with respect to inmates hanging up uniforms, towels? I think there's a blanket. Do you acknowledge that that was occurring while you were jail administrator?
Yes.
Do you think?
Sorry, I just for vague, if we could firm up that question, because I think there's been a distinction made between them hanging it up for something less than 10 minutes, as Sergeant Wilbur said, and other forms of hanging up.
Right.
Right. So that, can we just be clear on that for the record?
Sure. So do you acknowledge that there were some technical rule violations with them hanging up uniforms, towels, blankets, for periods more than 5-10 minutes?
You know, I never noticed that. I know that we were allowing them to put up blankets to go to the bathroom. And if it was up longer, then we would go in and check on them. But if they were occurring, I did not know, because that was one of my huge concerns, was that safety issue. If it was happening, I did not see it.
I think you mentioned that there was a gentleman who was hanging himself that you had to go in,
Yes.
and did he have
And
something?
that left a huge impression on me.
and-
I actually went and saw a counselor about that, because it was huge.
Understand. And did he have something hanging up in front of the cell?
Towel. He had a towel.
So that kind
Sure,
of,
but can we be clear on the time frame?
when was that?
That was, well, Sergeant Wilbur was my partner still, so that had to be 6-7 years ago.
Sure.
I mean,
Okay.
even when Max gave me that letter that day, my first concern was he walked out and I had to make sure he got out of the building and didn't go anywhere, because it's a breach of security. And I was more worried about him making it out of the building without doing anything than wondering what the heck was going on. I was seriously in so much shock. I had no idea about anything. And then 2 minutes later, after getting to my office, I get called to Brian's office, and I was like, what the heck? And I honestly, I think I remember a third of what was said, and I did not remember him saying anything about resigning. After I was sent the recording, I heard that and I was like, oh, I didn't even know he said that.
Sure.
Because I think I probably would have accepted it at that point, but, you know.
Did you have a chance to review, I forget the detective's name, who did the sexual assault investigation?
No, I asked him numerous times how the investigation was going. He said he was still reviewing video. He never gave me any reports or copies of anything.
Okay, I'm sorry, then that was Detective Pierce. So
Correct.
you never saw his report. Did you ever see any of the videos that he watched?
No, I did not.
As a part of this process, this grievance process, you've gotten a copy of it, of the report, I believe at least.
Yes, we got that.
Did you have a chance to review it?
I did.
Are there any things in there that stand out to you as being just patently false?
Mm, Like, what do you mean false?
Well, you know, in reviewing his report, is there anything that you read in there is that, no way is that true?
I mean, the way he has it written, he does make it. I don't know. Hold on. Can I review this for a sec?
Yeah, absolutely.
I just
Absolutely.
wanna-
But I need you to review it and answer my question and not have your attorney help you.
Yeah, no problem.
Thank you.
Dude, that's just part of it. Because I gave you the entire thing yesterday.
Yeah.
Is that that?
Yeah.
Okay, then I'll get this on this side. Good.
while she's reviewing, did you have a chance to hear back from Mr. Grady at all?
I hadn't, but I just got a text. No. Text my two to let me know when he's. He said initially it would go till 5 though.
I'm gonna get a little more coffee. If you have an answer, when you have an answer, wait.
Okay. Well, I mean, if he watched video and is saying that this happened on the video, then it probably did happen. I was not allowed, I mean, I didn't have an opportunity to watch any video. However, like, Sergeant Wilbur was saying, Sergeant Wilbur was saying they were shorthanded. And so, I mean, if they were in the cell together, you know, for 2 minutes here and 3 minutes there, then that could definitely have happened. But also, I never did talk to Detective Pierce. At one time, he came over to my office actually about the facts of this. Actually, he came over to my office and said that domestic violence liaison Amy was going to be interviewing some inmates about it. So, I mean, other than that, yeah, it's a tragedy that if it did occur, but obviously the DA didn't even think there was enough, the burden that they didn't meet the burden of proof. So, and I certainly hope that they learn from it. I know that we tried, I set up staff meetings and trainings after this, which we also had before this too, but set up trainings to make sure people are keeping a better eye on people and not putting stuff up. So.
Sure. And I appreciate that you haven't had a chance to review the videos to make sure that what Detective Pierce is saying is accurate, but any reason to doubt him?
No.
And I think you just kind of said this, there was some remedial measures taken after, I suppose, October to try to make sure that this does not happen again.
Yes.
When did you take those actions? What did you direct and when?
I set up some retraining for staff, for certain staff members who were having more issues than others. And I set up regular training. I also had a mandatory staff meeting to talk about any issues that we were having in the jail.
When approximately did you start doing all of those things?
Well, I mean, I've been having sergeant meetings all the time. I was having them all the time. Every day I met with my sergeants. But staff meetings is hard because we were so short-handed. Plus, we couldn't really get people to come in on overtime. So we had only had a couple of staff meetings over the last year. But in all honesty, everyone was working as hard as they could and doing the best that they could. I commend my staff for how well they did under the circumstances.
Of being understaffed?
Understaffed, the COVID conditions, all kinds of, I mean, there was a lot of stuff going on.
Did you ever advise Chief Deputy Zupke or Sheriff Brennan of the remedial measures you were taking?
Yes,
Who did you advise?
Sheriff Brennan,
Verbally or email?
verbally.
Okay.
We also had daily meetings.
Okay. Those are the questions I had. Back to Attorney Hitchcock Cross for redirect.
All right, thank you. So just briefly, I guess, so you hadn't, the first time that you saw this, the full investigation file for the alleged sexual assault, when was that?
This reported?
Right.
Yeah, when it was sent from Max Lindsey, I got it, I saw it on Tuesday when you forwarded it to me.
Okay. So that's, just to be clear. Okay. So, and because I think part of the question is this investigative summary? I mean, is it true that, well, let me add back up. Is this investigative summary, is this a criminal investigation or is this a personnel investigation?
Criminal.
Okay. So when you're saying you don't have any reason to dispute what's in the report, we're talking about the criminal findings in there.
Correct.
Okay. And does this report, based on your review, identify any work rule violations?
Yeah, actually it does. And
I just want to be clear on what you mean with that. Does it identify facts that could lead up to work rule violations?
yes,
Okay. Does it actually specify which work rule violations were alleged to have been violated?
yes.
Okay. What are those work rule violations?
If they had their blankets up longer than the allotted time that we give them, and so whoever was working that day would have been written up.
Aha, okay. So let's talk about the 3-page letter. Does that say anything about blankets or anything being blocked?
No, I know it doesn't.
Okay. When was the first time you learned of issues, allegations against you regarding sheets, other fibers being hung up, fabrics being hung up in the jail?
today. I mean, can we review that?
Is it possible it was after you filed the grievance?
Oh,
Is that correct?
definitely, very definitely.
Okay.
I can't hear,
We're
I
talking-
couldn't hear the question or the answer on
The
that.
question that I asked was, did she learn about the allegations that there were sheets hung inappropriately or contrary to the rules before or after she filed the grievance? And what was your response?
My response was, I recall it being well after when I received the response to my grievance.
Okay. And when you first found out about this in September, you participated and investigated in the investigation of
Yes.
the alleged sexual harassment.
Yes,
Okay. And then when it was stepped up to sexual assault, you were you took what the steps that we described before. Is that fair to say? Okay. And again, you didn't investigate the sexual assault because you're not a trained investigator, right?
Correct.
Okay. So it wasn't until after you filed the grievance, but the testimony that we've heard here today was that the county even didn't know about any allegations or issues with sheets up until Mr. Pierce was completed with his investigation, right?
correct.
Okay. And just going back to those remedial measures, because I guess you took some after October 23rd, but before you were terminated, whenever that was, you took some remedial, I guess we'll say before you were walked out, you took some remedial steps with regard to the sexual assault, right?
Yes.
What were those steps?
Well, not directly because I did not have this report, so I didn't know if anyone had any rule violations.
Okay.
But just from the letter that the victim wrote, I did take remedial steps, but that was from what the victim had written. I didn't write anybody up on violations because I was waiting to hear back what the actual report findings were.
Okay. I got it. So for example, when you got that letter, you hadn't questioned any inmates under oath, right?
No,
Okay. And you didn't investigate with other employees, right?
no,
No. Okay. And again, that's all based on the policy, right?
yes.
Okay. So
I did, however, speak with the inmates to let them know there was an investigation going on and to just be patient.
okay. But and I guess part of the question is when you're saying you took remedial action, that wasn't because you felt responsible or guilty for the things that were later identified in this Pierce
No.
report.
No,
Okay. And or acknowledge that what was when you were taking remedial action, you weren't acknowledging that what was in the Pierce report was true and accurate, right?
right,
Because you didn't know about it, right?
Right.
Okay. So just again, the training, the staff, all of that, the meetings, that would have all happened between October 23rd and the time that you were walked out, right?
yes.
Okay. So I guess the examiner zeroed in on the point in time when your relationship with Mr. Zupke broke down as being sometime in November 22nd of 2022, right?
Well, it may have been earlier than that, but I know that he accused me of having secret meetings with the sheriff. So I informed him that I was not having secret meetings. The door's always been open. Come in and sit down and listen. And that's why I wrote that email to let the current Mick Brennan know, hey, Brian is gonna deal with this when he gets the sheriff's office, or when he gets the sheriff's thing. And so, don't do anything about it anymore.
When did you hear this accusation for the first time that you were having secret meetings with the sheriff?
Shortly after Mick came back from vacation.
Okay, sometime in November of 2022.
Yes,
I got it. Okay. And again, there's no known rule or policy violation for having secret meetings with the sheriff. Isn't that true?
no,
No, okay.
or meetings at all.
Any meetings with the sheriff are just fine. Is that accurate?
Yes.
Okay. So, and you heard Mr. Grady say that you were having secret meetings with the sheriff, right?
Yes.
Okay, you heard that more than once, right? Okay, and in fact, he stated that that was the reason that he decided to terminate you.
Yeah.
Okay. Now, just again, to follow that pattern of the question that the hearing examiner was asking, at what time did you discover, or what time was it clear to you that your relationship with Mr. Grady had broken down?
Grady? Well, when he said, call off your dog.
Okay. Did you have any further discussion with Mick Brennan about that comment after that happened?
I did.
Okay, how did that conversation go?
He said, he told me specifically, I want you at those board meetings. You are the jail administrator and you need to be there, and you've been doing nothing but good since you took over, so I want you there.
So in fact, the sheriff, the actual constitutionally elected sheriff, was telling you to go to those meetings, right?
Yes,
Okay, and the county executive, can you tell us if he's elected or not?
he's
He's appointed by the board.
Right, okay, so this non-elected county executive was countermanding orders that you received from the constitutional sheriff, right?
Yeah.
Okay. And the constitutional sheriff countermanded those orders, didn't he?
Yes,
Okay, so then you continued to go, didn't you?
I did.
Okay. And then did your relationship, and when you continue to go, did it ever improve with Mr. Grady?
It only got worse.
Okay. And then again, you've discovered waste, fraud, and abuse committed by Mr. Grady in November of 2022, right?
I'll object to the
Wait,
classification of that.
You passing a budget, sir, with last year's budget numbers and refusing to respond to it is waste, fraud, and abuse.
I don't know that's fraud. I don't know that's abused. Might be waste, but it's totally irrelevant here, to be quite honest. So let's move on.
It's totally irrelevant that she called out the county administrator for passing a budget with fake numbers and not having any money in the account with which to operate. And then she's fired approximately a month and a half later. That's irrelevant, is what you're
If you're
saying?
going down the route of a whistleblower, it might become relevant.
Okay, so we're not on the same page then, that if he fires her because she calls him out for committing waste, fraud, and abuse, but he says that he's firing her for some other reason because she's having secret meetings with the sheriff, even though that's not a legitimate reason, that's somehow reasonable? Is that where we're headed here?
Per the grievance policy that I'm bound to, I have to look at the reasons submitted by the county to determine whether or not there is a rational basis for her termination. You have the burden, clear and convincing, to prove that they're irrational.
Right, and one of the ways to prove that they're irrational is to prove that they're false. We've already been over that.
Right.
Right. So if the real motivation, for example, is sex discrimination, race discrimination, age discrimination, waste, fraud, and abuse, going after the whistleblower, let's say attacking her for democratically protected activity, the free speech, if that's the real reason, then you have to find that the false reason is irrational. That's not, if you're playing this game here, that whatever they come up with, as long as there's some possible thing in the record that tie it to that, that's not what the standard is by any stretch of the imagination. The standard is, did they do any sifting and winnowing? Did they make a deliberate decision? And to ignore the fact that there's clear evidence because that's why you've let it all in so far, that they did this, that these are just pretexts, that's not doing your job. That's not judging. That's also not the standard.
I understand.
I'm glad that we got the standard out here clear, because again, it says unreasonable. That doesn't mean that there's any, that they can point to any basis. What it means is that there has to be a sifting and winnowing process. So if we can show that they didn't do that, or again, they're lying, that's unreasonable. A false reason is unreasonable. Made up garbage is unreasonable. Putting her out, sex discrimination is unreasonable. Age discrimination is unreasonable. Let's say going against the whistleblower, as you just identified, for waste, fraud, and abuse, for identifying waste, fraud, and abuse and saying that it's really for some other reason, that's unreasonable. So I think that I really appreciate here you clearly identifying what the standard is and giving us this opportunity to correct that knowledge. Because absolutely, you've got the wrong conception here. I'd like you to read again my pre-hearing report, which I think clearly lays out the standard. Part of the problem is that I had to spend an entire day researching what the hell unreasonable means, because there's no guidance of any kind. But when you look carefully at appellate review of any kind, both of agency decisions, of grievance decisions, of actual circuit court decisions by the appeals court, and up to the Supreme Court, we can see what that standard means. And again, it means that there's no evidence of sifting and winnowing. There's no deliberation, because that's one of the government functions that they have to do in order to satisfy due process.
Are we getting into closing arguments now, or?
No, we're not. Thank you.
Well, it kind of just seems like we are, but
No, what we're doing is clarifying what the actual standard is, because you've stated an incorrect standard on the record. And so now we're trying to clarify that.
the standard is set forth mostly in the grievance policy. I will clean it up a little bit in my decision, but it's mostly there, okay? Let's finish up with your client's testimony, and then we can get some closing arguments done.
What is that? I didn't understand your last statement. You said you'll clean it up in the final decision, but it's mostly there. What does that mean?
So when I write these decisions, I usually put in there what the legal standard is, so that you can clearly see what it is that I am applying, okay? You are free to disagree with it and appeal it and, do with it as you wish. But I will clearly articulate the legal standard by which I'm going to apply here.
Well, you already did. That's the problem. So you put a statement on the record, changing it in your decision later on is not going to really beef it up at all. When you just said again, the statement that you understood for reasonable is not actually an articulable standard upon which, meaning that's any basis whatsoever. Okay, again, false statements make it unreasonable. A false decision makes it unreasonable. And so when you sit there and say that all that has to happen is they have to point to some particular fact that points to this being justified, that's not what the standard is. The standard is that there has to be some sifting and winnowing, some actual decision making going on here. And again, evidence of a false decision is clear evidence of the standard that is unreasonable. That is the same thing as arbitrary.
Okay, let's move on.
Arbitrary means
All right,
that you are unable to point to any basis for the decision, or if you read the pre-hearing statement, or no evidence of sifting and winnowing. Yep, that's what happens.
Stop,
No evidence of sifting and winnowing.
stop.
Well,
Please go move on with your client's testimony. We're gonna wrap this up.
I'm also noting here that I was not quite finished, that I've been urged to stop and not prevented from making my record.
When you get to closing arguments, I'll welcome you to argue as long as you want what exactly the standard is, what the law is that I should be applying. Okay, let's get the testimony in and then we'll deal with legal arguments.
All right. I appreciate those statements, sir. I appreciate you getting them on the record. Thank you.
Do you have any more questions for your client?
It doesn't sound like there's a point. So I appreciate that, making that clarity. So no, we'll decline to go further based on the bias that we've been seeing here.
Mr. Lindsay, any more questions?
No, Your Honor.
Okay, I don't have any more either, so, we need, do you have any other witnesses?
Just Mr. Grady.
Okay,
I mean, if they brought the history of Mr. Kadat, so we can do that if you want, about how much he gets paid. We can have him bring in his pay stub then, if that's what you want, Mr. Lindsay.
What are you talking about?
what are you asking for? I didn't understand.
We'll have Mr. Lindsay, Mr. Kadat come in and tell us how much money he makes. Let's get that happening.
I think that's in an email.
Well,
That's
so
for
we
you.
just had this line of questioning from Mr. Lindsay about she doesn't know what he's actually getting paid and she hasn't actually seen his pay stub. So
Well,
let's have
and
him bring in his
and I,
pay
no,
stub.
I told Mr. Lindsay, I don't care. To be honest, I don't see that as being an issue that I need to spend a bunch of time on. There's an email that already has it.
Great. Let's get to Mr. Grady then.
So you have Mr. Grady. Do you have any other witnesses? Okay, so we just need to have Mr. Grady and then finish up. Did he contact you?
No, he hasn't yet. He's been in the hearings all day. It's almost 5 o'clock when he thought he'd be done. I guess while we're
Exhibit 17 has Kyle Kadat's wage.
trying to get a hold of Dan. And just, I guess, get a decision or an opinion, the hearing grievance policy leaves it to the discretion of the hearing officer for opening or closing statements. I believe it limits it to 10 minutes. Yes. I would request to have a closing statement. If the hearing officer would allow.
What page is the closing statement on?
49. Of the,
No questions optional. I also know if that was the grounds on which you cut me off before.
what?
I was making an objection And you all cut me off on our basis that we would have a closing statement. And then he said that he was gonna let us have the time that we wanted for a closing statement.
Yeah, so the. What the world is that? At any rate, I mean, it sounds like you're both willing to do closing statements. That's fine. I don't care if it's 10 minutes or half hour, to be honest. I'll leave it up to you guys.
I do love my rhetorical exercises.
I'm sorry.
I love, let's say, rhetorical exercises.
I tried calling also. He's in that here. Maybe we can watch on C-SPAN or something.
Wisconsin,